And counterpart has arrived. Okay, we are ready to start. Attorney Bolt, I believe you represent the appellant. Is that correct?
Yes, Your Honor, and good morning.
There's a cross appeal too.
There is a cross appeal, and so one of the things that I thought we would just briefly touch on up front is how you'd like us to proceed. I guess technically we're both entitled to rebuttal time since given the cross appeal, so I figured I would reserve. I didn't know exactly how much time the court had given us.
Oftentimes we ask if you guys have worked it out how you would like to do it for the betterment of your presentation, because if we go with 2 rebuttals, then I'm going to have to figure out which part of the arguments are responsive to only rebuttal and that type of thing, which I don't mind doing, but I don't want to make someone feel they might have missed an argument based on what status of the proceedings there are. If you wish, then we can do it. Mr. Frickin, did you want to have your, I guess, your rebuttal on your cross appeal as well?
Yes, Your Honor.
Okay, so Attorney Bolt, how much time do you want to reserve?
I'll reserve 4 minutes, and it may be less than that, but 4 minutes, Your Honor.
And Mr. Fitkin?
I'll do likewise.
All right. So let me see if I have this right. We will, you will make your presentation. Mr. Frickin, in your 16 minutes, you will do both a response and your cross. Then Attorney Bolt will respond for the reserve time to the arguments and rebut to her argument. And then Mr. Fritkin will get his response to whatever Attorney Bolt says as to his cross appeal.
That's satisfactory, Your Honor.
Oh, good. We're going to really tax my technological skills this morning. Gosh, and I don't get paid any extra for doing this. Okay. Let's go ahead then. I have made the notes on my thing, on my notepad, and hopefully I will get the sequence right. Attorney Bolt, we are prepared to go. You may proceed.
Okay, Your Honor. And may it please the court, I'm happy to be here today arguing before Your Honors. So in our initial brief that we filed as the first appellant, our issue is, of course, the mailbox rule, which is one of these interesting issues that we've all thought about way back since our days in law school. But our position here in this
exactly what Justice Alito said. You learned it in your first year of law school.
Exactly, right from the very beginning, one of those types of issues. So for us here, our position, very simply, is that the trial
but customarily, isn't that used for the acceptance of an offer to form a contract?
Customarily, you're 100% right. That is really where it initially developed, was in the offer and acceptance framework of contract law. And then what we have is it began to be applied in the context of payment provisions under contracts. And we've cited to the court several cases that deal with that and deal with it applying in the payment context under contracts. And here, the trial court specifically decided that that she was not going to apply the mailbox rule in this case. And it's important in this case because, as the court's aware, we're dealing with a breach of a lease agreement. And the issue was,
Ms. Bolt,
yes, Judge.
Putting this out of order, but trying to maybe streamline and make this a little bit easier, we don't get to the mailbox rule issue unless we find merit in the second part, in the cross appeal on the amended final judgment. Am I right?
You're right. You're right. In other words, if the court decides that it's going to uphold the amended final judgment finding forfeiture, then there really is no need to go back and look at the mailbox rule. So, and I think that's what Your Honor was referring to.
It is. And so it's a little bit backwards, but it also, I think, makes sense in looking at this thing.
It is backwards, and you're right. You know, and that's why, that's why I wanted to talk about it up front. It is a little bit difficult to decide sort of which order to do the argument, because you are right. Technically, we could start at the back and come forward, or begin with the mailbox rule.
And what I was hoping to engage you about is the back the back end. Okay, I don't procedurally I haven't defined the terms for how to describe the amended final judgment, but take me through the timeline. Your opponent's position is the trial court lacked jurisdiction to enter the amended final judgment. And my understanding of the timeline was that there was a bench trial, the trial judge made an oral ruling, and entered the final judgment on the 26th of April and amended it on the 17th of May. And the motion for relief, that there's some dispute as to whether it's a 530 or 540 motion, was filed before either the final judgment or the amended final judgment was entered. And if I understand your position, it is that the trial judge had jurisdiction, among other things, based on the pendency of that motion, and also because the final judgment wasn't, the amended final judgment was entered based on that motion, which would have, I guess, been timely because it was already pending. Help me understand.
You're correct. And I think that your timeline is correct. So we have a one-day bench trial. Subsequently, the court has another hearing where she provides the parties her oral ruling. So it's at that time that she says, I am ruling in favor of the landlord. And then there comes the motion. And you're also correct, Judge, that the motion does not specifically state which rule it's being brought pursuant to, but it's very clear from the face of the motion that it is directed to the court's ruling that the court has already orally told the parties about.
And so, because she hadn't reduced anything to writing, one way of looking at that motion would be sort of a garden variety interlocutory motion for reconsideration. Is that correct?
I think that that's also a fair rule reading of it. I think that when you look at Rule 1.530, of course, although it's called the motion for rehearing, it's also, you have subpart G, which says motion to alter or amend the final judgment. So our position is that even though the motion does not specifically say this is being brought pursuant to 1.530G, that when you look at what it was seeking, it's clearly a motion for.
So, okay, so I'm good with your procedural, I think I understand your procedural position with regard to the vehicle of the motion, if you will. Talk to me about the basis for the motion and the issue of whether your affirmative defense is sufficiently and fairly encompassed the substance of the motion. So, because I think your opponent's position is this issue came up at the 11th hour, only after the ruling had been made dispositive, and it was essentially an ambush or otherwise hadn't been pled sufficient to allow you to seek that relief.
Right. And of course, we don't agree with that. If you look at the transcript from the trial, which we have in fact cited in our brief, at the point in time, well, let me actually back up, Judge, because let's start with our affirmative defenses, which is where we should start with. It is definitely correct that the word forfeiture does not appear in our affirmative defenses, but when you look at the facts that were pled for avoiding the relief that they were seeking in our affirmative defenses, we plead both the lack of materiality of these breaches, and we plead that there was substantial compliance. And all of these are factual bases for relief from forfeiture, even though the specific words were not used. So that's where we stand on sort of the strict pleading issue. Then we come forward to the time of the bench trial. And at the trial, we specifically said that we are now ready to put forth our evidence that supports our affirmative defense. And the trial court heard, there was a little bit of argument about it. And the other side's position was that it just wasn't relevant. They never argued. So part of our argument on appeal is that there's waiver in connection with that, because they never made the objection that this testimony could not come in because it had not been pled. They just simply argued that it wasn't relevant. So the testimony then comes in, and the testimony that comes in that helps establish forfeiture is, for example, consistent with the Fowler case from the 3rd DCA, the amount of renovations that had been made to the premises, the number of employees that worked there who would be put out of a job if the forfeiture was allowed. We then go on to the fact of the court's ultimate ruling that you had, if all 3 of her rulings are upheld, meaning the 3 breaches, you have 3 payments that were untimely by very short periods of time. I mean, on the one that we're raising by the mailbox rule, it should have been paid in the light most favorable to the landlord. It should have been paid by the 7th, and they received it on the 9th, or it's postmarked on the 9th. And our testimony is that it was mailed on the 6th. So when you
I want to redirect you, because I read your brief, and I believe my colleagues probably did too, on the mailbox rule, and understand the record behind the timing of those payments and the history of the 3 payments. Your opponent is arguing for that the trial judge in the first judgment enforced the terms of the lease, matter of law, and that going into the amended final judgment, the trial judge couldn't fashion a remedy that deviated from just a strict textual interpretation of the lease by reinstating essentially the renewal options that were technically forfeited, albeit on short-term discrepancies with regard to receipt of the rent. This action comes to us post a declaratory relief. So I'd like you to speak to whether the trial judge was empowered to grant what amounts to equitable relief after having initially declared the legal impact of the lease on these facts, that, putting aside the mailbox rule, your client didn't get the rent in on time, and the lease says if the rent doesn't get in on time 3 times in a row, no more renewals. So now the trial judge says, as a matter of equity, because of the build out expenses and so forth, I'm going to do this. Your opponent disagrees that was proper, and I'd like to hear your position on that.
Certainly. So yes, the case law is very clear that this is allowed because it's an equity. And you know, when you look at those cases, and I think it's important to note that one of them is in fact a 2nd DCA case. That's the Artia case, and that's cited in our brief, and that's at 170 Southern 3rd, 884. And that's a case where the appellate court, this court, upheld relief from forfeiture. And then we also have the Fowler case.
Ms. Bold, I'm sorry, I know I'm interrupting you.
No problem.
We're talking about forfeitures. The sort of the cloak on this is equity abhors a forfeiture. And we're speaking of it the way that you would be speaking of it in sort of an eviction sense. But that's not what this lease was, at close to the end of the initial term. And so what's been forfeited is not the leasehold as it existed on the day the lease was made, but instead the renewal options, or at least the first renewal option. Does that fit in the forfeiture analysis? And I'd like you to speak to that so that I can best understand your position on, because I think there is a difference between sort of an organic leasehold and an inchoate renewal option.
Well, I would agree with Your Honor, except for the fact that, and I believe I have this right, that we were entitled to, my client was entitled to 3 subsequent 5-year extensions. It was either 2 or 3, so I might have the number not exactly correct. It was either 2 or 3. So, and this would have been the first renewal. So the first of the 5-year renewals. Well, that is a significant right. I mean, to have put in the amount of money that this client, that this tenant put in to build out the premises, and the amount of money spent there. The whole point of that is because they have not just, it's not like the lease is just going to be over in 5 years. They have multiple options for renewal.
And my
So-
question to you is a little more discreet and technical. And it is, and I don't think I saw it in your briefs, but you have a lot of briefing in this case. So if I overlooked something, I want you to help me. Is there any difference between, as I said, an inchoate renewal option, which is essentially what you had here, and a leasehold, the organic leasehold, for purposes of this forfeiture, the equitable forfeiture analysis? Or is there anything that you can point me to that directly supports the position that the renewal is equivalent in the forfeiture analysis to the leasehold? And I understand the equitable circumstances that surround the argument, and that from your perspective, it probably doesn't matter because the tenant made these investments, but I'm asking for if there's any legal treatment.
I believe, Your Honor, on page 37 of our brief, we cite the Holmes regional case. That's out of the 5th DCA. And in that particular case, the court applied the equity of horse forfeiture in the context of an option to renew a lease. And I think that the reason that I was saying what I was saying earlier is it makes sense in the context of a situation like this, where obviously you want a long-term tenant, you want a tenant that's going to stay for extended periods of time. So you have a lease that has a 5-year term and then these multiple 5-year renewals. And so it's because the tenant knows that they have this right to have these renewals extend out into the future is one of the reasons why they would spend the amount of money that was spent here, which I believe was $1 million, to increase the value of this property and to make it what they wanted it to be for purposes of serving, as the restaurant and bar. So I think that 5th DCA case, makes a lot of sense because of the interests that are in play when you've got a lease with these particular types of terms. I hope I answered your question, thoroughly.
You have. I'm afraid I may have used a lot of your time.
That's okay. I think that, but I do agree that if the court upholds the ruling on the forfeiture, we really don't have to go back and look at these other issues. But we did raise the mailbox rule because we do very much believe that, number one, as we all know, it's a question of law for the court. So,
well, since we were going there,
Yes.
Isn't the record clear that the envelope was not postmarked until the 9th?
Clear.
And that on the 9th, even if it were deemed received on the 9th, that's late, isn't it?
It is. Well, what the
mailbox rule doesn't help you.
No, I disagree with that. And let me just explain why. The
You're
mailbox.
at 16.
Yes, Your Honor, I'll wrap it up. The mailbox rule says that delivery occurs upon putting it in the mailbox. And so the undisputed testimony at trial by Ms. Pooley was that she placed it in the mailbox on March 6th. And she knows that for all sorts of reasons I won't get into here, but basically quickly, she had an event that she had to attend in Miami. So she's very clear on when she put it in the mailbox. She put it in the mailbox on the 6th. So if the mailbox rule applies, then it applies because it was mailed on the 6th, which would be the receipt date. I will save my time, Your Honors, and come back to you on rebuttal.
Very well, thank you. Mr. Frickin, you're up for 60 minutes, and I'll be giving you the same warning.
Thank you, Your Honor. May it please the court. I want to start where Judge LeBrit was picking up on, and that is what was most egregious to us out of two appellate points was the granting of this amended final judgment. to go back to the timeline again, the final judgment itself was entered April 26 of 2019, and it found that there were 3 late payments as a matter of fact, one of which is in dispute here in this appeal. And that as a result, under section 8.7.1, the option to renew this lease was canceled under the express language of section 8.7.1. There was, after the oral ruling, a motion that is described as a verified emergency motion for relief from forfeiture that was filed. And that was filed before April 26. There was a characterization, both in the briefs and in argument before you, that this was a motion for rehearing. But the fact is that at the hearing on this motion itself, counsel for the restaurant tenant said these words, quote, "To be clear, this is not, it's not a motion for rehearing." So the trial judge was being told that it's not a Rule 1.530 motion.
I'm going to interrupt you. Does it
Sure.
matter?
I believe it does.
And if it does, how or why? I mean, you're basically in an interlocutory situation when this motion is filed. And when
Because, well, I was hoping to try to answer the question. Your question was, does it matter? And I believe the answer to that is yes, because there's nothing in Rule 1.530 that authorizes a party to inject a brand new issue that was never raised in any answers, never raised in any case management disclosures, never raised in the bench briefs.
Well, what about the affirmative defenses that your opponent just pointed out to us, and the trial by consent issue that's been briefed and that we talked about a little bit in her argument?
Yeah, neither of those apply. Let's start with unconscionable forfeiture. If you go to your own Atria case, that does not stand for the idea that unconscionable forfeiture would have been granted in this case, because that was a summary judgment reversal on the issue of whether there were material facts. But there's an important indication in Atria that under the right facts, in fact, forfeiture applies. It was allowed to be considered as grounds for reversal in that case because it was raised as an affirmative defense. There are none of the cases that have been cited by the restaurant that would support the idea that you can raise these issues unpled. So Rule 1.530 is intended to call into question things that were in front of the trial court that were misapprehended or weren't properly ruled upon. It's not.
Let's assume, for the purposes of this argument, that the defenses that were pled encompassed the argument that became the basis for this motion, and or that the issues were tried by consent during the bench trial.
Okay.
How does that change your argument if it does?
It would resolve the jurisdiction issue, both jurisdiction over unpled theories and jurisdiction being timely, and that would then put us into the case of, is it wrong as a matter of law? And I would take your attention to the case that Judge Casanueva wrote the opinion on back in February of this year, the JF and LN LLC case, which said, and
that's a material breach case?
It is. It is.
Restaurant?
Correct. That's exactly what it is. It's where Your Honor wrote that we conclude that the breach by reason of the timely failure to pay rent was a material breach of the underlying lease sufficient to support the cancellation of the option to purchase. I would suggest that language
in that case, wasn't there a total failure to pay?
There was a payment of an insufficient funds.
And it was rejected.
What happened was the insufficient funds check bounced, and the tenant immediately came back and said, here's your money. You didn't and the trial court ruled that it was immaterial because the hotel had cured so quickly. Your Honors reversed because you found, and this is consistent with what the rule really needs to be in the context of commercial leases, that timely failure to pay rent is a material breach. If that isn't the rule of commercial leases, then the commercial leases as written throughout this state are meaningless. And you'll be, every time there's a late payment, you've got a new issue. The contract should control. Waxman, similarly, cited in our materials, is your court ruling out of the second DCA that where the contract is explicit on an issue, the doctrine of equity abhors of forfeiture cannot be applied. The contract prevails over the equitable principle. And lastly, the Seuss case, also cited in the brief, is this court's admonition, as has occurred repeatedly in the past with the Emerson case, that courts are not empowered to rewrite. And this amended final judgment not only rewrites, it tears up section 8.7.1. Under Waxman, under Seuss, it cannot do so. And the materiality affirmative defenses are disposed of in the JF and LN because this court reversed the trial court where the trial court had canceled the option and had ordered specific performance. So let me jump quickly to the factual finding of 3 late payments. Only one is in question. That was the payment that was evidenced by the envelope that had March 9, 2017 on it. In evidence in front of the judge was the Postal Service's handbook, which says, quote, that says that a postmark is, quote, the date the Postal Service accepted custody of a mail piece. That judicial notice was taken of that handbook, and that was evidence to support a finding that on March 9, 2017, that payment had not been delivered to the notice address of the landlord, which is what is required under section 4.4 of the lease. So the deposit acceptance rule, as Your Honor correctly called it, not only doesn't apply because it doesn't apply to payment, and that is the law in this district, whether other districts have separate or different versions of this. This court in the Morrison case was very careful to point out that the deposit acceptance rule should not apply to other areas of contracts, such as specifically that where the envelope contains a payment, that the mailing is not actual payment. And that language is in the Morrison
case. Let me
case.
get you ahead of that. What was the due date in this lease?
So
Fifth of the month?
It was payable on March 1. And when you go to section 8.7.1, it becomes late if it is not paid within 7 days.
Okay.
So within 7 days would either be at the latest March 8. I think there's an argument that it would mean March 7.
March 7th or 8th, one way or the
Yes.
other. And so this payment, if we view the mailbox rule as applicable, and I hear you telling us why we shouldn't, but if we do, it was placed in the mailbox on March 9th, and it was received a handful of days later, and the check didn't bounce, and it was payment of the rent in full.
Correct.
Right?
Yes.
The other 2 payments that are not disputed were similarly timed in the sense of being full payments that were a few days after the last day of the grace period.
That's correct.
And so you want us to hold as a matter of law that those were material breaches sufficient to extinguish the renewal option.
Absolutely, exactly right. Yes. And
does our record tell us where the box was, where it was placed in the box for mailing?
The physical box was located at the premises of this building on Fifth Avenue in Naples,
Okay. And the postmark, does it tell us where it was postmarked?
Fort Myers.
So it was picked up by the mailman, taken to the sectional center in Fort Myers where it was processed, stamped, and then sent back to Naples for delivery?
Correct. So let me go to the last but not least on this, and that was the summary judgment that was granted by the trial court on the issue of gross receipts. Oh, but before I leave, the testimony of the bookkeeper was inconsistent. The bookkeeper testified under oath originally that she mailed the check on March 2. She was forced to recant that testimony, changed her sworn testimony to March 6. And the trial judge, you could see if you read her ruling, did not accept the issue of whether or not that is actually what occurred. And according to the law, the trial judge's findings as to credibility really should not ever be disturbed by a court of appeal.
Let's use your time.
Yeah.
The percentage rent argument, I'm interested in hearing how tips for wait staff are included in percentage rent under your theory of this case, when we all know that, and I don't think this record contradicts this in any way, the landlord doesn't keep those. Now, they sell plates of food, and that's the percentage rent that your client wants to drive off of. As the landlord, they succeed, we succeed, everything's great. But how do tips fit into a percentage rent calculation when the tenant doesn't keep any part of the tips?
Okay, I would disagree. It doesn't keep any, but let me answer your question. The language at issue in the lease, these parties are free to contract. The language in the lease is that the percentage rent gross receipts include amounts received for services performed. When you go to the definition of a tip, it is money for services performed. If you go,
it's amounts received by the tenant for services performed. Say, for example, if the tenant caters a wedding on the premises,
well,
that might
be amounts received for any business occurring through the tenant at the premises.
Wait, you're saying amounts received by anybody for a service performed on the premises then?
What the record below shows is that the restaurant was receiving hundreds of thousands of dollars in tips directly into the restaurant's bank account.
And they cashed those out to the wait staff.
They cashed out on a different basis. They kept cash and they reconciled things as best they could day in and day out. But the record establishes that hundreds of thousands of dollars a year, both under their point of sale records and under their bank deposit records, but most importantly, under their federal IRS reports under 8027. Those reports report gross receipts to the IRS, and that gross receipts number includes all of their tips and gratuities.
Does the lease purport to define the gross receipts for percentage rent purposes in accordance with IRS guidelines?
Absolutely not. It defines it simply as amounts received for services performed.
Did your client put any evidence in the record in the way of expert testimony or International Council of Shopping Center guidelines or anything like that that would support the notion that in the restaurant industry and the landlord-tenant setting of percentage rent, wait staff tips would be included as gross receipts?
Well, the correct answer is we didn't get to trial. We were deprived of a trial at a summary judgment hearing or actually not even a summary judgment hearing. Trial briefs submitting this evidence, so as, for example, that gross receipts, according to the IRS, actually include amounts received for services performed because they include all of the restaurant's tips in that definition of gross receipts. So it wasn't something unusual to have the words amounts received for services performed to include tips and gratuities because those are subsets of amounts received for services performed. Under the Campiello case, if you're concerned that it is a reasonable reading of the lease to exclude tips and services and gratuities, despite the fact that they're not excluded under the expressed exclusions, then a trial's got to be required here. This matter has to be developed as a matter of fact, so that there's a factual record to answer your question and to answer the bigger question of what did these parties mean at the time they contracted? But the language reading it, applying its plain and unambiguous language can only come to one conclusion. And that is because amounts received for services performed is broad enough to
even if the receipts
absorb.
are not, even if the receipts ultimately are not received by the tenant. That's your
Well,
position.
but
Let me say this as you get ready to frame your answer. We're at 16.
yes, the answer is absolutely. There's nothing in public policy that prevents a restaurant from paying a landlord, even if it costs the restaurant money at the end of the day. Thank you.
Your Honor, what I would like to do
Hold
is,
on, I have to stop his clock from running unless you want to start at 16:35, which would mean you're way out of time. Hold on. Allow me to use what few, there we go. You have 3:20 remaining.
yes, sir. Okay, I'd like to start with the last issue first and then try to work my way backwards. First of all, tips are discretionary. And when it's a discretionary matter, that makes it a tip and that makes it not for a service performed. Services performed under the Fair Labor Standards Act, under all of the employment law, means a mandatory service charge. So, Your Honor, Lambert, you had a good example. For example, if they hosted a wedding and they charged a certain service fee for hosting the wedding, that could be included into gross receipts, but not these tips that are discretionary that our client never kept, obviously, because that would be a violation of law, tips that belonged to the wait staff at the restaurant. And our position is that that's very clear. Now, let me talk a little bit about some of the issues here. The landlord filed a motion for summary judgment on this and believed that the issue was right for a legal determination by the court. We cross-moved for summary judgment. So the parties totally believed this was a legal matter for the court to decide. The trial court denied that in just a simple order. And by the way, that was denied very shortly before trial, within a couple of days, maybe even the day before. And then the morning of the trial, the judge, after asking for a briefing from the parties, a trial brief, looked at this issue again. And then I came to the conclusion that both of the parties had come to, that it was a question of law for the court. So there is nothing here that needs to be tried. There is just no question, but that when you look at the law on this, that the phrase amounts received from services performed cannot be interpreted to include tips. And the law is very clear. I'm going to go on because my time is limited. I wanted to go back to the case that Your Honor, Judge Casanueva was on, the JF and LN case recently. And Your Honor is, of course, correct about that. That was a total lack of payment, a total failure to pay. And here, because I want to go, this is a little bit of a public policy argument. Opposing counsel is arguing any breach of a contract, any breach of a lease contract has to be determined to be material. Any breach of a payment provision has to be determined to be material, because otherwise what's going to happen out there in the world? Well, this is a case like these other cases like Fowler and like Artia from this court. This is a case where you have total, complete, substantial compliance. By the time of trial and shortly after these 3 payments that were late, they were full, complete payments. They were not partial payments. They were not checks that bounced. They were full, complete payments. So the worst case scenario is my client, the tenant, was late by a couple of days on 3 payments. And by the way, don't forget, When the trial court determined that those 3 payments constituted late payments, it triggered another provision of the lease, which required us to make an additional security deposit of more than $60,000. And our client did that immediately. So they have received every single payment due under this lease. They have received now a subsequent deposit of monies of more than $60,000 that they are holding. So this is not a situation where they are owed a single penny.
I
And
need to
that
tell
is
you your time has in fact expired a few moments ago.
okay.
I want you to finish your thought. Thank you.
But that is why we think that the court's ruling should be upheld, or at a minimum, the mailbox rule should apply. But in any event, we seek an affirmance of the trial court's rulings below. Thank you, Your Honor.
Okay. Let me do the math. Mr. Fritkin, you have 330.
Your
Actually,
Honor,
333.
okay. On that last issue, the public policy, there is no public policy that stands in the way of a landlord and a tenant defining for their own purposes what a gross receipt is supposed to be. The gross receipt definition used in this lease mirrors in a great deal the gross receipts definition to the IRS, but it doesn't make reference to the IRS. Clearly, the IRS under Form 8027 requires gross receipts to be reported that include tips and gratuities. And this tenant knew it because it's been doing it a long time. In order to get to the gross receipts definition in the lease, as they
Mr.
admit,
Fricken, who drafted the lease?
it was a joint exercise between the landlord and the tenant's lawyers, and there is a provision in there that says that it shall not be. Yes, right.
And we can all agree that it doesn't explicitly include tips.
Yes, clearly, it does not. And our contention, obviously, that they disagree with is that if tips and gratuities were to be excluded, there is a specific exclusion provision under gross receipts, such as sales tax. Okay, sales tax was expressly excluded.
And that's because the sales tax gets remitted to the state, right?
Well, that's right. And so by analogy,
like the tips get remitted to the servers.
well, but and that every amount received, whether it's for sale of goods or for services performed, are applied to the operation of the business. At the end of the day, that's what happens to it. But if the idea was to exclude tips and gratuities from gross receipts in light of the language received for services performed, they needed to be listed because they fall within, as do catering fees, as does a service charge because you have more than 10 people at a table. All of those are subsumed into the words amounts received for services performed. And again, if that isn't clear, and if that's ambiguous, a trial is required by virtue of the Campanella case, which we cited in the brief, which is a 4th DCA, which, interesting enough, had exactly this issue. It had to do with the issue of, quote, gross receipts under a lease and ambiguity. And the 4th District ruled that where you have those situations, you must have a trial to develop the evidence. By the way, that position is consistent with the 2nd District, which says that if there truly is an ambiguity, if both parties have a reasonable reading, then a record at trial must be developed. And again, there's nothing in the public policy that would prevent that. Going back finally to the situation with respect to the amended final judgment, between the Waxman case, the Seuss case, and the JF and LN case, it is quite clear that courts aren't to rewrite provisions to rule that the parties couldn't be judges for themselves of what is or is not material. The
I need to
party,
advise you that your time has expired, but as I provided Attorney Bolt, you have 20 seconds to sum up.
so the parties have the power to describe what is material and what is not. Chronic late payment was described specifically in 8.7.1. As the court has said in the Seuss case, trial courts are powerless to rewrite the contracts. Thank you.
Thank you both. Have a good holiday and please stay well.
Thank you.
We will
You
let
too.
you slide over to the other part of the technological world. I have no idea what it is.